announcement?
No.
Today we want
Taking video.
Alright, you can say. Okay, we are very gratified on the outcome of the hearing today, because I must say the judge was extremely fair in the assessment of the case as well as the delivery of his judgment. The Prime Minister's lawyers sought 40,000 on which was also on an account of indemnity basis, which means if Roy has ran a frivolous defense as well as some sort of dishonest defense, then he should be punished for that, and therefore indemnity cost should apply. The court rejected that argument, so Roy has not filed any frivolous defense or frivolous constitutional arguments, so therefore the court gave $20,000 as cost to the Prime Minister's lawyers. So it had been halved, it is 100% less. We are extremely happy with this outcome, and so we are of the opinion that justice is met, at least at this stage of the cost. I won't comment on the assessment of damages as yet. Now, the Prime Minister's lawyer had indicated that the Prime Minister is only to be cross-examined, or rather the Prime Minister to be cross-examined for 1 day in the event that Roy does not file any affidavit. Alright, which means without Roy being cross-examined by the Prime Minister's lawyer, there has to be 1 day cross-examination only for the Prime Minister. My short response to this is, I was asking for 3 days, alright, which means excluding Roy's cross-examination if at all he files an affidavit. He has indicated now Roy has indicated that he wants to be cross-examined by Prime Minister's lawyers, and he is not afraid to be cross-examined by the Prime Minister's lawyers. That's what he said. Now, my response to the Prime Minister on this account is that it is quite disconcerting that the Prime Minister should leave the kitchen if he can't take the heat as a Prime Minister. He should be able to be cross-examined by me for minimum 3 days. That was my submission to the court. So therefore, as I said earlier, that the Prime Minister is the primus inter pares of first among equals of all the ministers. So he should be able to take the cross-examination. So 1 day is definitely not sufficient, in my humble opinion. And also, since Roy and the Prime Minister has 7 other witnesses, the 7 other witnesses who are lawyers and paralegals of Drew and Napier, who had filed affidavits on behalf of the Prime Minister, who will be filing affidavits on behalf of the Prime Minister. I've asked that the Prime Minister's lawyer submitted that they don't have to be present in court, because they are not going to be cross-examined by me, because they filed all the Roy's articles and all the papers that he had already been available on the internet. My objection is that Roy will suffer a breach of fair trial. Just like in criminal cases, all witnesses, if you bring them as witnesses, they have to be cross-examined. It is the discretion of not the judge, it's the discretion of the witness to cross-examine or not the witnesses. Just like in criminal case, right? Photographer will bring a list of witnesses. So therefore, I submitted that it will be a breach of Roy's constitutional rights. A right of fair hearing is a procedural injustice will follow if the 7 witnesses, aside from the Prime Minister, from Drew and Napier's office, do not come to court for cross-examination. I indicate I'm not going to cross-examine them, but they have to be examined on oath, which means their evidence must be admitted formally. Otherwise, that will not stand, even if they are documents. All right. So the court allowed my argument, directing that all the witnesses should turn up. The 7 of them from Messrs. Drew and Napier. We were informed that 2 of the witnesses have left Drew and Napier. One of them is in Dubai. So that will inconvenience and add extra cost to Roy. That was what the Prime Minister's lawyer submitted. I said we are in an era of technology, court. Singapore is not short of any technology. So the technology court could be utilized, and they can Skype or they can be in Dubai, and they can give evidence from there. And the court said yes, they could, yes, I gave evidence from there because this has been done. I believe, because I don't do so much of construction matters, well, I'm familiar with commercial litigation and arbitration, some form of arbitration work. I'm not, handled this bit of it, but nevertheless, they could be examined. Although they have left through an APA, they could be examined, and the court have allowed that. So there's no cost involved. And then the inconvenience of Drew and APS lawyers, I mean the 7 of them or the 6 of or the remaining 5, the Prime Minister's lawyer submitted that it's inconvenient, right, for them to be, and that will also add extra cost and all that. I said they are only in Raffles Place, and this is Supreme Court. They can just walk straight. What inconvenience is that? All right. So I'm sure the Prime Minister can handle this part of it because I'm sure he's resourced, and the guys just need to walk. They need to affirm, and they can go back if they want to. But I understand from Mr. Singh that they'll be assisting Mr. Singh in court. All right. So now the matter has been, Roy had to indicate to the court by 30th of January as to whether he's filing his affidavit evidence in chief. He's willing to be cross-examined. He has confirmed that he is willing to. I will write to the court and through an APA, CCing them a copy that Roy is willing to be cross-examined. So the cross-examination dates will be longer now. Dates for cross-examination will be longer, and what number of dates is to be determined on 23rd of February 2015, and on that day the judge will decide how many days he's going to allocate for the trial. Now the other feature is that as to when this trial is going to take place, the court wrote to us saying that sometime in July to August that the courts are available. Mr. Singh said that he has got some matters in High Court and so on and so forth. He asked Mr. Singh, as in the Prime Minister's lawyer, for May that he will be comfortable. But I objected, saying that the court had indicated to us already that July to August are the available dates that the judges have. So I've made my arrangements. You know, I'm launching several constitutional challenges, which I've indicated to Terry and Andrew Lowe have shared with them as well. And they are forthcoming challenges. So in view of that and some challenges to the mandatory death sentence, I'll do capital cases as well. And I also will be flying out of the country for some of these constitutional cases as well as commercial matters. And I am only a small firm. I don't have the resources of doing anything. So therefore, the court understood my position as a small practitioner. The fact that I've already given commitment to my London Queen's councils and all these people that I'll be visiting to prepare myself for the various work that I've undertaken to my clients. So I have to complete them. In those circumstances, the courts considered about October available dates in October that they are available, but subsequently the court found that they have a slot in June. Now the Prime Minister's lawyer asked that maybe perhaps 2 days to be taken, and then another 2 days if at all, in the event that the trial takes 4 days. I objected, saying that once the witness leaves, in case I cross-examine the Prime Minister for say for example even 2 days or even 3 days. So once the witness leaves the court, they could be coached. And also it is disorienting to have a separate tranche, 2 days for the Prime Minister and then give another 2 months gap and all that. So usually the witnesses, so I'm of the opinion that the Prime Minister, we should have 4 days, and so the witnesses can be cross-examined without having to discuss with their lawyers what's the purpose of cross-examination. It has to be done on the spot, right? And the responses should be elicited. Should they have a gap, there could be a possible coaching. I'm not saying that Mr. Singh is saying that he wants to coach his client, but these are standard practice, standard observations are made universally as far as the juristic nature of, or rather the legal nature of the manner in which procedures are administered when there is a trial. Alright, so we are extremely thankful to all the online media who are present here. Straits Times, Mr. Channel News Asia is not here, it's understood. Alright, they are state media. So Straits Times, I think they'll report accurately. I've given them my piece. Channel News Asia won't be here, as you know. Anything which is contentious, anything which is not favorable to the state, they won't be here. Alright, so we are not surprised. We are not surprised. If this is America, we will be having a field day in Speaker's Corner I would be addressing. No, it's just a joke. All right. We are not. We are nowhere close to. We are nowhere close to France. All right. That's it.
His office. What? Okay. Okay. You can just send. That's just me, thank you. So that's his thing. I'm not taking a selfie. So that's his thing. Okay. Maybe you take a few steps backwards. Harder than narcissism. Oh my god, he's so narcissistic. Oh, nice one. Thank you.